The bankruptcy court is no longer a court of equity. That is a plausible, albeit extreme, reading of the decision handed down by the U.S. Supreme Court on June the 4th in a case called Lamar Cofrin versus Appling. I am Bill Rochelle, Editor-at-Large of American Bankruptcy Institute, and that is the topic we will discuss on this week's installment of Rochelle's Daily Wire video edition. Let's go back to the year 2014 and the Law versus Siegel opinion written by Justice Antonin Scalia. That case involved a bad man who had a very large fraudulent transfer liability to the bankruptcy trustee. The trustee could not collect, so the bankruptcy judge helped out by allowing the trustee to invade the man's homestead exemption. That's a result, I think, that many, if not most, bankruptcy judges would also have reached. But when the case goes to the Supreme Court, Justice Scalia says, no, you can't do that. The man is entitled to his homestead exemption by statute. And the bankruptcy court, he said, does not have a roving commission to do equity and in the process override the statute. Now then, in the term this year, in the Appling case, we have a somewhat similar case, but with a different twist. Here, the debtor made a bald-faced lie to a creditor about the existence and value of one asset, not his entire net worth, but one asset. Of course, had he lied about his entire net worth, that oral statement would not have rendered the debt non-dischargeable. The bankruptcy court said that because it was just a lie about one asset, it was non-dischargeable. That, again, I think is a result that many courts would have reached because they don't believe that people who lie in a bald-faced manner should get a discharge of debts. But in the Supreme Court, Justice Sotomayor said, no, the plain language of the statute tells us that that's a statement of financial condition, and therefore, although it was a lie and a bad lie, the debt is nonetheless dischargeable. Again, we have the statute undercutting the ability of bankruptcy judges to do equity. Draw your own conclusions, but this seems to be a pattern that has been ongoing now for some number of years. To read more about the Lamar Cofrin case, read my story on June the 4th on the ABI website. Until this time next week, this is Bill Rochelle saying good day.